Hi, I'm Brian Wiklendt with Garfinkel Schwartz. I'm here in our Maitland, Florida office today, and we have a deposition of the client scheduled. So come on in, I'll show you around. Under the Defense-Based Act, the insurance company has the right to do your deposition, to take your deposition. That's before the court hearing happens. They have the right to ask the questions in a leading type manner. They have the right to do that for what's called discovery purposes, so that they know that all their questions can be answered by you, so they can get a proper assessment of the claim as to whether it should be settled or whether they want to take it to trial. Depositions occur after your case gets transferred from the Department of Labor to an administrative law judge. Once the administrative law judge, sometimes this happens earlier, but that would be by agreement of the parties, but once the administrative law judge sends his trial order, he gives deadlines for depositions and written discovery and things like that, and that deposition is then transcribed into a transcript. It's under oath with a court reporter. The insurance companies usually go through your entire life, pretty much, starting in high school all the way through when you got injured, all of your experience level, what exactly happened to you, what your version of the events are, any witnesses that you might have. I then have the right to depose your treating physicians for trial and get explanations as to what they've said in their medical records to more properly explain what your condition is. It's not something to be really concerned about, but it's definitely something to prepare for. And what I do is I always go in person, no matter where you are, to the deposition, and I always prepare my client the day before the deposition. Way back when I worked for large companies, that would be a firing offense in my old firm if you didn't properly prepare the witness at least the day before the deposition, because traffic occurs, things like that happen. And if you're not properly prepared, you're not really going to know exactly how to answer the questions. Now, I don't coach people. That's a word that I'm not allowed to say. I don't coach you. I just prepare you as to what to expect, why the questions are being answered, and that if there are objections to be made, then I'll make those appropriate objections if the question is inappropriate. Sometimes I've seen if you go into a deposition without an attorney, it seems like the attorney from the insurance company could take advantage of that and start asking questions that may not be appropriate. So if you don't hire me by the time you're at the deposition stage, when you're getting ready for a formal hearing, you should hire someone that knows exactly what they're doing and has prepped hundreds of people for their depositions, especially under this law. And so hopefully that was some good information for you. You can call me or email me anytime. I'll be glad to help you through the process any way I can. And again, I can also still monitor cases. We do that all the time. But when it comes to litigation and depositions, you really should be represented by that point. And so again, Brian Wiklendt, Garfinkel Schwartz, signing off from our Maitland office. Thanks for listening.